question is, who gave you these names? They're not in the affidavit. We can look at it for the next hour. You will not find the names in 4 up to 12. Somebody gave them to you. Who gave you these names? And under what circumstances?
This application came to me from the prosecutor.
So Ms. Ramsame will have to tell us where she got these names from.
That would be correct.
Okay.
Did you inquire from her where she got the names from when you know that you only gave her the Section 27 affidavit and you are quite familiar with it? Yes, do you engage and say, who are these ones now? Where do they come in? How do they come in? They are not in the affidavit. You are not conducting an investigation yet, so you are not obtaining your own evidence. Where do these names come from? Did you have that engagement with her?
I didn't have that.
Why not? Shouldn't you have? Because from what you are suggesting, it's like she looked at those 3 names and said, no, 3 is not a good number, I prefer 12, and start like somarkhoying other names in there. And you signed, and you are happy with that. How come?
As I indicated, according to me, she only had the 27.
Yes.
And she would have then put together the 28.
Yes.
Yes.
Which we're looking at.
Yes.
And you know the 27 doesn't contain the names from 4 to 12.
That is correct.
So why do you sign it in the form that it is, where suddenly it includes a litany of other people who are not mentioned in 27 affidavit?
Sorry, Counsel, you refer to only the first 4?
The first 3.
First 3.
The first 3.
Yes.
And sorry, Commissioner Baloy, that I'm now a bit slow. I don't intend taking the whole afternoon to.
Well, I'm just trying to be helpful.
I'm trying to figure out how she would have arrived at the names, because their official capacities mentioned, but the names are not mentioned. I take the point.
You accept that it is not from the Section 27 yes. affidavit that yes. she got the names.
Yes.
You accept that someone must have, if they come from her, someone must have given her these names.
Correct.
Yes.
And I will find out.
And you accept that at this point, when she approaches you with this application, the investigation hasn't started yet. You gave her the affidavit, she looked at it, and she came back to you and said, we need to have a preliminary investigation. So you accept at this point, there's no investigation yet.
Correct.
All right. Thank you.
My challenge is this, Advocate Johnson. You are authorizing an investigation into 8 people who are not mentioned in the singular document you have. They are not referred to you. There's no complaint regarding them. But you are authorizing an investigation into them. In terms of what section are you acting in so doing?
A conversation must have happened.
With who? That's a question.
With Advocate Ramsamy.
No, she's not conversing by her soul self. Who is she conversing with?
What I'm saying is, she and I must have had a conversation.
Oh, so you are aware of them?
I'm saying she and I must have had a conversation, and I will follow that up, because I don't have an independent recollection of a conversation. And she would have to indicate then if she had a conversation with somebody else. I wouldn't just have blindly signed it without finding out from her.
Did you perhaps suggest these names to her?
No, these are not people I know.
Can I say the difficulty is that you don't seem to abide the terms of this Section 27. Even if she proposes the names to you, you are the final decision maker. You are the in charge. You are the one that's authorizing an investigation. It's difficult to conceive of a situation where she comes back to you and she gives you a list of names and you don't say, no, we can't do that because it doesn't arise from this affidavit. We haven't started an investigation, so I know you didn't get those names from an investigation. I know you didn't do that. We have at this point only this affidavit, and you don't say we are obliged to work with what we've got. We can't do whatever we feel like. It's difficult to understand that you would be party. If this is her giving, she gave you these names, that you are happy to sign off a truly invasive investigation, because your powers to hear evidence means you can call these people, you can look into their affairs. That's what it means. And you do it outside the corners of the only document you have on which you could work with. You, the head, are not in a position, and you do not say to your prosecutor that we are not doing that. We are bound by law, we are bound by rules to investigate that which is properly given to us. It's a misuse of powers, whether it comes from her or from you at this stage. This is a misuse of powers. To take intrusive steps and action against people on this affidavit, you have no justification whatsoever on this affidavit to be looking into Likalakala, Ngube, Moyani, Sibula, Madileng, Mukwele even, by name, Duvalo, whoever is automotive engineer. You have absolutely no legitimate and valid basis to look into them. Maybe there is something to look at later on, but we are still at this affidavit stage where you are authorizing that they be called in, that their affairs, their bank statements be looked into, and their lifestyles and everything and about them. And they must come to interviews under threat of, if you do not cooperate, it's a criminal offense. You're happy to do all of that, when in fact the document, the only document on which you rely to act as you do in this document, doesn't create a basis for it. It's to me, it's yet another instance where you, in particular, have misused your powers to go where you are not authorized to go. There's no legitimate basis to do this. Do you want to comment?
I have no comment. B.
Was there a sufficient factual substratum to satisfy B of Section 27? That's the question. And I think in response to my question, you've accepted that there was none.
In terms of the factual basis of it, yes.
The factual basis that undergirds or supports the factual conclusion.
Correct.
You've accepted that there was none.
Yes.
Do you then accept on that basis, because my and your engagement has started on the basis of the first suspicion,
yes,
which is state capture? Would you accept that there is no factual basis advanced in this affidavit in respect of all the suspicions as you have identified them? Would that be correct?
That would be correct, except he says so of
his conclusions.
His conclusions of, I have information, and I receive information, and I also had information. It is on that basis, yes.
If that's where we land, would such an affidavit comply with the requirements of Section 27? And what would be the consequences of non-compliance?
So given the questions that were posed by the chair, it was, I had not looked at it.
And not only the questions and the responses.
Yes. So on the basis thereof, commissioners, I've applied my mind differently. The commission has pointed something out quite differently that ought to have been considered. I'm saying in the manner in which I applied my mind at the time, based on how I understood Section B, or what Section B to mean, at the time, yes, I agreed that it fulfilled that requirement because he had knowledge. He had grounds on which it was based. I've I've given the answer, Commissioner. I can't change that answer.
Are you seriously telling us that since what you've been the director since 2022, is it?
Yes.
Are you telling us that since 2022, this is how you've understood your legal mandate, or IDAC's legal mandate?
No.
Did I understand you correctly to suggest that you understood that the suspicion required has to be viewed subjectively? Did I understand you to say that? I'm asking you this because you said you believe that he had the required suspicion. He, Mr. Adams.
Yes.
Did I understand you correctly?
Correct.
So that's subjective as opposed to objective. So did you understand the test to be a subjective test as opposed to an objective test?
For me, the grounds on which the suspicion is based is a subjective test.
I will.
No, I'm not going back on the argument.
Okay,
I'm saying in the way I've applied my mind, this is a reasonable suspicion that must be borne by a reasonable man and person, by a reasonable person who must have access to knowledge and or information that brings them to that point. If you would allow me to just take it just a moment further.
Yes.
Mr. Adams is a member of the Police Portfolio Committee. These allegations come to them from time to time. There's active engagement with the police. There are documents that are shared. There's information that is shared. I did not take his to be just the test of a subjective mind of just a reasonable man.
No. You can't obfuscate issues in the manner in which you are saying. You said you considered the test to be subjective. Now you are saying something that suggests that somehow you also considered it to be objective. You cannot have it both ways. Please, Advocate Johnson. Let me ask you the question again. Did you consider the test to be subjective?
Correct.
Now, what are you saying? You've just said something that seems to suggest that you also considered it to be objective. Make me understand what you are saying.
Maybe I didn't express myself correctly. I'm saying that the reasonable man test, the person test, applies. But
once you see, therein lies the problem. Once you say that the test is subjective, then you look to what was going on in a specific person's mind. That's subjective. It has nothing to do with a reasonable person. That's subjective. You cannot have it both ways. Law 101 says subjective, you look to the person's mind. Objective, you test that in accordance with how a reasonable person would view the situation. The two are totally different. You cannot want to compound them. You simply cannot. You cannot say it's subjective, but then also refer to a reasonable person test. You cannot. I mean, even a law student doing first year would know that.
Malo Lushaba Madondo and other senior crime intelligence officers were busy with the systematic capture of the crime intelligence division. Let's just sit with that one suspicion. Where in this affidavit do I find grounds to support that suspicion, which then would take A and B of Section 27?
So, first, in paragraph 2, line 1, Commissioners, he says, so the cases he refers to above must refer to what follows. And he says the cases were opened based on information I received from time to time, which places the SAPS crime intelligence, and then it follows. So he receives information from time to time. And he then says in paragraph 3 that that suspicion became even clearer when an envelope pushed under his door at Parliament contained crime intelligence procurement documents using secret funds of crime intelligence and vetting documents. So the grounds on which he bases it is information he receives. Information he receives from time to time, and further expounded by the fact that he has this envelope with further information that is pushed under his door. That is the genesis for the grounds on which his suspicion is based.
But you said he did not give IDAC that information which was slipped under his door.
That is correct.
So that's like saying, I have grounds, but I won't tell you what they are.
May I explain a further process that then happened? And sorry, Counsel, may I?
Absolutely, ma'am.
Because it might seem to jump the gun, but it will then perhaps provide more clarity. We received the section 27. We received the dockets. IDAC takes the stance that an engagement has to happen with Mr. Adams because this 27 he did on his own and sent through to us. We have the dockets, but when they had the engagement, having read the dockets, having read the 27, it goes back to what I said. You then engage the person to see if there is other grounds that need to be covered. And further statements, commissioners, were then taken in the engagements had with him in January of 2025.
I think where we are, Advocate Johnson, is that 27 says these things must be specified in the 27 affidavit. Because if you read 27, it says, by means of an affidavit or affirmed declaration specifying ABC. So ABC are to be specified in the affidavit.
Correct.
They are not to be established at a later point. So the entry point is the affidavit which specifies A, B, and C.
And it is for those reasons, Commissioner Khumalo, that I referred to those two paragraphs. That is where I took that from, where were opened based on information I received from time to time and the information placed under his door.
If perhaps you may assist us then. The suspicion is General Khumalo Lushaba and Madondo and others are busy with systematic capture of the Crime Intelligence Division. That's a suspicion. You are satisfied that that affidavit contains grounds to support that suspicion. Can you summarize those grounds for us?
With reference to the affidavit itself, right?
Indeed. Thank you, Commissioner.
On my reading, Counsel,
yes, ma'am.
that suspicion is, he refers to the suspicion and he proceeds to explain, as he does in paragraph 4.
And what grounds are articulated in paragraph 4?
Says that he suspects that General Khumalo and some senior officers in crime intelligence, including
I apologize. I thought we agreed that paragraph 4 contains other suspicions. I'm still looking for the grounds for the suspicion that Khumalo et al. Are busy with systematic capture of crime intelligence. Where are the grounds for that? The manipulation of procurement processes and processes to a point is another suspicion. It's a different one.
Yes, and I'm saying that it is based on, I don't read it to mean that every single suspicion is supposed to have a ground. If my reading is incorrect,
No,
I'm saying that is how I read it. I read it as I received information from time to time. From that information I received from time to time, there are all of these allegations, inclusive of the documents under my door.
You wanted to invoke paragraph 4 to establish the grounds. Remember, we still have to comply with section 27B.
Yes.
So we're going to have to at least find the grounds for the suspicion reflected in paragraph 2. You say those grounds lie in paragraph 4. And if you could just summarize them quickly for us. And simply because my reading of paragraph 4 is slightly different, but I'll take your perspective.
So the suspicion of the systemic capture lies in his suspicions in paragraph 4 in terms of, he refers to the procurement, manipulation, for lack of a better description, manipulation of appointment processes, bypassing of the vetting. Those are the ones that talk to the systemic capture of the crime intelligence division.
He's not in paragraph 4, and what you're referring to now, he's not giving you facts that support his suspicion, because that's what 27B requires, the basis for his suspicion. What he does in 4, on its terms, he says, I suspect, that which you're referring to now, he says, I suspect that General Kumalo and other senior officers in crime intelligence, including Madondo and Lushaba, were manipulating procurement processes and processes to appoint and promote certain members to higher positions. So it's a suspicion. So you can't say, when we ask you that, okay, he's made the suspicion to you, so let's say he complies with A, what are the grounds that he has stated in his affidavit in support of that suspicion? You can't say where he states manipulating processes, procurement processes and processes to appoint, and then you say those are the grounds. That's faulty reasoning. It is a suspicion on his terms. It is. He tells you, that's what I suspect. The question to you is, where in the affidavit did you find that he has put down grounds for that suspicion?
On my reading, Commissioner Baloy, it is found for those ones on paragraph 3, where he said, my suspicion about General Kumalo and others became more clearer when I found an envelope pushed under my office door at Parliament, which contained some crime intelligence procurement documents using secret funds of crime intelligence and vetting documents. I can take it no further than that is my reading of where he finds these suspicions.
Factual conclusion after factual conclusion, Advocate Johnson can never give you the facts that undergird those factual conclusions. All of the things you are addressing now are themselves factual conclusions. Do you understand what I'm saying? Do you understand what I'm saying?
If you could just take
those are factual conclusions. Let me
Yes.
give you. Let me give you. You agree? Do you agree?
I understand.
Those are factual conclusions. Do you agree?
I agree.
So, if we go back to Ms. Silo's question, she wants to understand what that factual substratum is. What facts do you rely on to say those factual conclusions, and you now accept that they are factual conclusions? What facts underlie those conclusions to lead to the fact that B of 27 is satisfied? On what basis? It cannot be on the conclusions. Let me give you an example. If someone says, I suspect that Tom and Dick killed Harry, that's a conclusion. For you to be satisfied that there is a reasonable suspicion that Tom and Dick killed Harry, there must be some substantiation before you say Tom and Dick killed Harry. Do you get me?
I understand.
Otherwise, it's a factual conclusion to say that Tom and Harry killed Dick. And I suggest to you that this is exactly what you are doing. You are relying on factual conclusions to say that B of Section 27 has been satisfied. Do you agree?
I agree.
You accept that proposition?
I accept your proposition.
Yes, Mr.
Thank you, Chair. And then following that very same
Of legal studies. In fact, across the board within legal studies, you go to your law of delict, you go to even criminal law, your culpable homicide, you encounter the reasonable test across the board. So how you could mix the subjective test and the objective test completely escapes me. So back to my question, you have said you accept, or rather you say the test under Section 27 is a subjective test. Do you stand by that? Because if you do, it raises very serious issues about your application of the section over all these years. Are you sticking to your assertion that the test is subjective, even though it uses reasonable? Once you have reasonable, that leads to the objective test. You should know that.
Yes.
Are you insisting that the test is subjective?
It is an objective test of the reasonable person.
It's an objective test.
Yes.
Yeah, you don't even need to go to reasonable person. Reasonable person is implied in the concept of an objective test. So you don't even need to go there. Now, if it is objective, did you operate, when you looked at this referral, did you operate on the basis that here I'm concerned with the objective test? Is that how you applied it? Because my sense when you responded to Ms. Sillo was that you thought it's subjective. And indeed, even here, until my 2 or so questions before now, you were saying it's subjective. It's subjective. So that must clearly mean that you looked at this referral affidavit on the basis that the test was subjective. Is that so? Is that so?
I looked at the Section 27 on the test of the
Subjective, it must be.
at the time, yes.
It must be, because that's what you believed. Hence your answers on a few good times now during this engagement, your answer is that the test is subjective. So you looked at this on the basis that it is subjective. You agree again?
Yes.
So that means in your case, the word reasonable, which appears in so many words in Section 27, did not come into the equation whatsoever. Is that so?
It does.
No, it couldn't. Not if the test is subjective according to you. It wouldn't. Because once you talk reasonable, that takes you to the objective test. And you have said, in your mind, that did not apply. So you looked at this on the basis that it was the subjective test that applied, correct?
Correct.
So reasonable did not come into the equation to your mind, correct?
The reasonable that comes to mind is as per any person has reasonable grounds to suspect. It dealt with the offences, which was Part A.
It's there fine and you are reading it fine. But what I'm saying is, if you believe that the test is subjective, then reasonable, on your understanding, does not come into the equation. Because once you bring into the equation the word reasonable, that's already taking you to the objective test. You have said on your understanding the test was subjective. Therefore, reasonable would not have come into your equation, not on your approach. You must accept that.
I hear you, Commissioner.
Do you accept it?
I accept that.
Thank you.
Thank you, Chair.
Isn't that even allowing for it was an error, you applied the subjective test because of your misunderstanding of the test that applies. Even on that, in this affidavit, insofar as 727B requires him to set out grounds, this affidavit doesn't set out any grounds. To say I received an envelope that has procurement matters, that's not a ground. It doesn't tell you anything about the contents of the envelope. For all I care, those procurement documents may well not demonstrate anything wrong. So it's not clear to me when you say, well, I accepted because he's a member of parliament who serves in the portfolio committee, that when he says he has an envelope that is sufficient, you surely must know and understand that for you to say this falls within our mandate, you need to satisfy yourself with whatever it is he's relying on. So I don't accept that what you say is an error on your part of applying the wrong test, that it explains what happened here. It doesn't. Even on that error, I would expect you, as you understand the section, it says he must set out grounds, and he doesn't. He doesn't. When he goes on to say 4 other colonels who qualified or who are employed in crime intelligence, none of them were suitable to be appointed in this post. It doesn't tell you anything about this candidate that was appointed. It doesn't. So it is clear in 27B that he does need to tell you facts. Subjectively, he thinks those facts meet the test, but you have to know those facts before you say, yes, our mandate is triggered. You must agree with me. I must be correct in what I'm saying.
I'm not about to disagree.
Okay, thank you.
Thank you, Chair.
Person gave us.
And Advocate Johnson, that is apparent from paragraph 4, because Mr. Adams says none of these people were suitable to be appointed to the post. That's his personal view without
Correct.
grounds to support that.
Correct.
He doesn't even say they did not meet the minimum criteria. They did not have the qualifications. He just says you appointed somebody from BMW as a brigadier. And then he says not suitable. Full stop. Why are they not suitable? Do they not meet the qualifications? He does not even identify the offense that he suspects is being committed there. Because appointment of somebody from BMW on its own does not tell you anything. Because my immediate question would be, what is wrong with appointing somebody, an engineer from BMW? If the position required an engineer, what would be wrong with it?
Correct.
That would be my immediate question. And I would need that to be addressed in the affidavit itself. Because the entry point, according to section 27, is that the affidavit must specify 1, 2, 3. Not that it must set out the suspicion and then the grounds, IDAC will figure them out for itself.
Understood.
Just on an answer you gave in response to Ms. Sillo, you said an error that you committed was not to apply the subjective test. The test is in fact objective. In that response, based on the answers you gave to me, and repeating the same thing a good few times throughout until your engagement with me, the distinct impression I got was that you've always understood the test to be subjective. Correct?
I understood the test to be the reasonable person test, which is an objective test.
Okay, I will not go back. I engaged you on the subjective and so on because you cannot marry subjective and objective. It simply can. Oh, let me ask you this question. So throughout your understanding of Section 27 was in accordance with the responses you gave when I engaged you as to what those were. The transcript will assist us. Throughout, that was your understanding. It is only now that you have clarity as to what exactly the test is. That is a test which is not subjective as you suggested it was, or a test which does not seek to mix a subjective and objective test. It is simply objective. So before now, you had, I feel bad to have to use this word, but your understanding was this muddled view of what the test was, which muddled view came out as I engaged you. So that was your understanding until now, until during this engagement. Is that a fair suggestion to you?
It is fair.
Thank you.
Can I just say, correspondence from Mr. Adams, you say the second paragraph and the third paragraph do not refer to that correspondence unless you're suggesting the minister must have had a telephone call with Mr. Adams, and that's why he's able to talk about these dockets, the content of these dockets. And I suspect that's not what you want to say. Because the next question would be, how do you know they had a conversation about the dockets and what's contained in the dockets? So let's read the letter sensibly. Paragraph 1 says, I attach a copy of the correspondence received from Mr. Adams. That's what it says. And then paragraph 2 says, the allegations contained therein implicate serious members of the South African police. I want to say to you that a sensible reading of this first paragraph and the second paragraph is the contained therein refers or must refer to the attached correspondence. That is a sensible reading. Otherwise, why does he mention that letter to you?
That is correct.
Yes. So your reading of it to say, well, when he talks about implicating senior officers and containing sensitive matter, he's referring to what is contained in the dockets. It doesn't work. It's not a sensible way of reading this letter. But more importantly and seriously, it works only if you say that the minister must have had a conversation with Mr. Adams about these dockets to know that matter contained therein in those dockets is sensitive and it implicates senior police officers. And who are those senior police officers? You agree with me? You must agree with me.
I agree with the reading of a copy of the written correspondence which would have set out those serious allegations as contained.
Yes.
And therefore the reference to the dockets because he refers to the dockets.
Yes.
But that the written correspondence would have set out these serious allegations.
Yes. That's the only way it works. Thank you.
And for that, you would have to go to page 283 of the same bundle. 283.
That is the correspondence we suggested was attached to the minister's
The serious allegations implicating senior officers are contained there because...
apologies, Commissioner. MK15, please go to MK15.
I am there.
And then to page 283.
I am there.
Thank you.
So that email of 1 November 2024 at 8:21, that is the correspondence addressed to the minister. And the docket numbers are there. And then allegation 2 is that I was told the dockets were intercepted. And then he says, I traveled to Johannesburg, Orlando, opened new dockets you see there. Then he implicates senior officers because he then says they interfered in the investigative process. And he was notified that Gauteng is following the same process. And the request to the minister is, I urgently and humbly ask the minister to intervene to ensure the integrity of the investigative process is maintained. So this is the request that gives rise to the referral to IDAC. And that was Advocate Sillo's point, that the referral to IDAC was about these allegations implicating senior officers, not for IDAC to go take over the dockets that were opened in Orlando and the Western Cape and investigate those underlying allegations in those dockets. As far as the minister is concerned, his letter was the Section 27 referral. Because if you look at the heading, they say referral and request for investigation in terms of Section 27. So as far as the minister was concerned, this is the Section 27. So the appropriate answer from you would have been, this does not comply with Section 27. That's the end of the story.
In fact, to add to that, nothing in this letter leads you to Mr. Adams. As Commissioner Khumalo says, it is the ministry that is referring and purporting to refer in terms of Section 27. And if you were going to ask for a Section 27 affidavit, it is from Mr. Nkabinde that you ask for, because he's the one that's purporting to refer. It doesn't direct you to Mr. Adams. The complaint has been laid with them, and Nkabinde says, I'm lodging a Section 27 complaint. And you have no business, at least on the basis of this letter, to go to Mr. Adams for a Section 27 affidavit. You go to Mr. Nkabinde for a Section 27 affidavit. You say to him, this is not a proper referral. If you want us to investigate in terms of Section 27, as Commissioner Khumalo says, give us an affidavit.
I read it differently, Commissioner Baloyi.
How do you read it differently?
It says referral and request for investigation in terms of Section 27. And it does make reference to the Honorable Fadil Adams. We don't have anything from Fadil Adams. And so the request to Perumal to get a Section 27 from Fadil Adams is based on the referral and request for investigation in terms of Section 27.
Mr. Nkabinde is asking you to investigate. Mr. Adams is not asking you to investigate. He has not communicated with you. He hasn't. Even on the version which on the proposition that I made to you, that you must have seen the emails that he sent to the minister, even on that, he's not directing anything to you. It is Mr. Nkabinde. He raises his complaint with the minister. That's what he does.
Yes.
The minister's chief of staff lodges with you a complaint, and he calls it a Section 27 complaint. The only reference he makes to Mr. Adams is to say, the minister has received a complaint from Mr. Adams. Please investigate. And I refer this to you in terms of Section 27. So the person that must give you the affidavit is Mr. Nkabinde, and it's not apparent why you thought that this is a complaint to IDAC from Mr. Adams, because it's not a complaint from Mr. Adams to IDAC. At this point, it's not.
I see where you're going to, Commissioner Baloyi.
It's like this.
No, sorry. Do you agree? Do you agree?
I agree with her interpretation.
Thank you.
It's like this. So Mr. Adams writes to the minister's office. He's unhappy about the 4 dockets, and he asks the minister's office to intervene. So the minister's office has at least 3 choices. One is the inspectorate, the other one is IPID, and the other one is IDAC. So they have those 3. So far, you are with me. You agree?
I agree.
Based on the nature of the allegations, as vague as they are, they have those 3 options. The minister's office then picks one, and they say, we pick IDAC. And we will do a referral to IDAC in terms of Section 27 of the NPA Act. It's not Mr. Adams who says, I choose IDAC. it is the minister's office, based on what we see in this letter. Do you agree so far?
I agree so far.
Yes. And they say, as far as the minister's office is concerned, the allegations in the correspondence by Mr. Adams, they regard them as quite sensitive. That's the minister's office. And they contain allegations of criminal misconduct. That's the minister's office. They then say, this office, that is the minister's office, this office requests Advocate Johnson to consider investigating the matter. That's the last paragraph on 310. So do you see that it refers to this office being the minister's office? Do you see that?
I see that.
And it is the minister's office that is asking IDAC to investigate.
Correct.
Yes. So the request is by the minister's office. And they say Adams was advised to await Advocate Johnson's decision. A decision on the request by the minister's office.
Yes.
Do you accept that? Yes.
Thank you, Commissioners. If I could just add,
Advise
To
the
say to Mr. Perumal, to Chief Perumal, speak to Mr. Adams, makes sense only if you've seen these emails and you've seen that there are allegations of interception of dockets. As you were starting to say that the email seems to speak to corruption of sorts. You have to have seen this. That's my proposition to you, that you must have seen these emails by the time or before you spoke to Perumal, and that's what informed you, saying to Mr. Perumal, speak to Mr. Adams. What do you say to that?
I can't disagree with you, Commissioner Balwa.
Thank you.
Sorry. Let me just follow up on a response you gave when I engaged you. So in the end, you accepted that you could not possibly have written a letter to the minister saying there's nothing we can do in the absence of a Section 27 referral. So you accepted your letter could not possibly have said that. I asked you, did you act in the manner in which you did because you were fearful of the minister? And I thought your response was in the negative, correct?
Right.
If you were not fearful of the minister, why then did you act? What motivated you to act in circumstances where there was nothing in the content of the letter from the minister? You were not fearful of the minister, as you suggest, but you still went ahead regardless and gave the instruction that you gave to Mr. Perumal. What motivated you? What was the motive behind your action? If it was not fear of the minister, what then was the motive for you to act in the manner in which you did?
Is to follow up on, is there a Section 27?
Is that all you asked Mr. Perumal to
That is
do?
all, because there's a reference to a Section 27. There is no Section 27. Mr. Perumal to contact Mr. Adams to find out if there's a 27 or to get a 27.
Did you say this before, or are you saying it for the first time? If you did say it, I may have not heard you. What I'm referring to as to whether you are mentioning it for the first time now is whether your instruction to Mr. Perumal was for him to find out if there was a Section 27 referral. Did you say that before?
No, Chair, I didn't say that before.
You are saying it for the first time now. I would have expected you to say that much earlier, but I will leave it at that.
I'm reading again.
Sorry.
Sorry, I was reading again and
In the absence of a Section 27 referral, we as IDAC cannot do anything. So that it would then have been the ministry that saw to it that a Section 27 referral was placed before IDAC. Why did you not write such a letter? Were you fearful of the minister?
Not at all. And that is
Why then did you not write such a
why I
letter?
said, Chair,
Sorry, you
Sorry.
spoke over me. Why then did you not write such a letter?
that is why I said, Chair, we'd have to look for the letter that the response. What did I write in my response to the minister?
But surely,
I don't think that I got a response.
sorry. But surely that letter could not possibly have said, Minister, we are not going to do anything about this because there's no Section 27 referral, because that would have been at variance with or at odds with you instructing Mr. Perumal to follow up with Mr. Adams. So that letter, even if we were to look at it, it's not likely to have said what I'm suggesting you ought to have done. So do you think that letter is going to assist you?
I'd have to look at the contents.
Do you think it's going to assist you as you sit there, seriously? Do you think it's going to assist you?
Not at all.
It cannot possibly do so. It cannot possibly do so because such contents would have been, as I say, at odds with the instruction you gave.
You forgot to attach the written correspondence between the Minister of Police and Mr. Adams, which you had kindly offered for ease of my reference. You didn't do that.
That is why I'm saying we need to look for the response to this letter, where I would have acknowledged the letter and in all likelihood would have asked for that which is short attached. Please find a reference. I would have asked for the written correspondence.
But definitely you recall you didn't have that correspondence
I
attached.
recall I didn't have that correspondence.
You then, as you testified, you instructed Chief Perumal to be in contact with Mr. Adams to obtain Section 27 affidavit.
That is correct.
Now, I want to suggest to you, so effectively, IDAC solicited a Section 27 affidavit from Mr. Adams.
I tell you now, when you look at the 27,
One who gave an advocate.
in my, I'm going into the detail that's not mine and not in my head, and I don't want to
It's
sound
yours. It's yours, Advocate Johnson. You are the one who gave an instruction to Chief Perumal to contact Mr. Adams. So Ms. Sillo's question relates to that. That has nothing to do. Mr. Perumal would then have been the actor on your instruction. That's where the question is. It has nothing to do with what Mr. Perumal then did down the line. So please do not deflect the question and refer to what Mr. Perumal would have done or not done. Can you please respond to the question?
Then you forgot.
That says nothing. That says nothing altogether. We do not even know what those allegations are, whether serious or not. That basically says nothing. And if I were to refer you to one of your own statements, I think that's your second statement where you were required to respond to issues about the docket which you are alleged to have shared with General Khan. You had, in respect of that issue, the ability to say this is vague. It doesn't say when, it doesn't say by whom, it doesn't say, and you went on and on to demonstrate that it was vague. That same thought process by you ought to have applied here as well. There are so many whys, how, by whom, when, about what exactly. There are so many of those. If you are able to apply that thought of process or that kind of reasoning, why did you not apply it here? It's on that basis that I say this says nothing at all. So by parity of reasoning, in accordance with your own reasoning, when you concluded that what you were being asked was vague, why did you not see this as vague as well? It says nothing, I suggest to you. Do you agree or not? That's it. Thank you.
So the upshot of all of this is that the referral to IDAC was by the minister's office. And following that referral, IDAC then made a decision to engage with Mr. Adams to obtain an affidavit from him.
It follows, Commissioner, yes.
And thank you, Commissioners.
And then fold your arms and do nothing. That escapes me.
Not do nothing.
You've just told us. Thus far, sorry. Thus far, you basically told us that you did nothing. All you did was to acknowledge receipt of the letter.
Yes.
What did you do then? If you did do something, what did you do?
I honestly cannot remember. I have to cast my mind back to, in the acknowledgement of the receipt of the letter, I speak under correction. I'm not sure that I asked and indicated that there was nothing attached to this letter, because a few days later, by way of envelope, we get the Section 27.
He would have been told to file a Section 27. I mean, he didn't make it up. He didn't wake up one morning thinking, oops, I have to put in a Section 27 affidavit. So someone would have advised him to file that. That's why it's important to know, what did you do? What did you say in that acknowledgement of this letter? You must have said something before we get to, you then received an envelope.
And the acknowledgement would have been typed from an internal computer. Surely you have that letter in your possession, or a draft of it somewhere in the computer, and it can be made available to the commission.
We have looked for it. I'm going to ask them to look for it again, because I also have to apply my mind. I can't, that is why it sounds like a fumbling answer, because I can't recollect what I would have written over and beyond. We acknowledge a receipt, and in all likelihood would have alluded to the fact that there is nothing there, because it talks to...
You said later in the year. Now that worries me, because the arrests were mid-year. So if later in the year is after the arrests, that is a problem. So when you say later in the year, what do you mean? Do you mean after June or before June 2025?
It would have had to have been before June 2025, because he became the investigator earlier on, which was
in January.
In January,
yes.
Yeah, I don't think it's an answer that that kind of question where you answer, it would have been. You have had opportunity to ask, and you were told you saw it later on. You either did ask and were informed when later on, or you must still go back and find out when exactly did he see it, because the way you're answering, you don't have personal knowledge of it, so you have to check with other people, and we shouldn't be left with the impression that yes, he saw it before the arrest because of how you've answered. I think it's a question that you must verify and come back to us with a specific period.
I will do that, Commissioner Baloyi, with the exact answer.
Finally, do you dispute his version when he says before this commission that he did not see the Section 27 affidavit? Do you dispute his version? Do you say he's not telling the truth?
I'm unable to dispute his version, because he's in that team. That is why I'm saying I have to ask the questions after the fact.
Thank you.
It's not my place to say he lied. He would have to, he explained as he did, yes.
Thank you. And thank you, Advocate Johnson.
You're still going to be discussing the Section 27 notice. I do have a question, but if